I go back to look at what it is the judges whom I admire, and most people admire, Holmes, Cardozo, Brandeis, Frankfurt, a lot of others. Well, how did they go about deciding these difficult constitutional cases? I mean, we're unanimous about 30, 40% of the time. The 5-4s are about 20 to 25%. It's not always the same 5 and same 4 either, but still there are very difficult open questions. That word liberty in the Constitution doesn't define itself. And we even talk about the freedom of speech. It doesn't quite tell you, in addition, what is the freedom of speech and what falls within and what falls without. And we're always at that borderline, that frontier, where there are good arguments on both sides. Well, very well, how did they go about it? So I said, well, I found some words that I rather like. The words in history. A judge in 1780 said the American way of deciding cases at the appellate level is, the words he says are prudence and pragmatism, reasonableness and utility. All right, I like those words. They sound a little like bumper stickers, but nonetheless, I like those words. Well, can we go further than that? I'd say, yeah, I think so. I mean, I think people approach this difficult job of construing that open language. I think that they very, very much look, whether it's a statute or whether it's the Constitution, look to the purposes of those who wrote it. Purposes are very important, general purposes, which are there in the form of values in this Constitution. Whatever freedom of expression is, it isn't about searches and seizures. It is about free expression. And you can find out quite a lot that way about what the values are. And so purposes are important. Values are important. You say, well, what are the values in this document? There's a surprising amount of agreement, and certainly at an abstract level. You say, I think all of my colleagues, I think everybody there would say what that document basically does is it takes a set of institutions that, as this has evolved, are designed to turn over to the people the right to decide what kind of cities, towns, states, nation they want through a democratic elective process. That's called democracy. But it isn't just that. It's a certain kind of democracy. It's a kind that also guarantees certain basic values, certain basic fundamental rights. It is a kind that separates power vertically, states, federal, and horizontally, 3 branches, so no one becomes too powerful who is in the government. It is a kind that guarantees a certain amount of equality, and it is a kind of democracy that insists upon a rule of law. Now, once you've said that, you have the basic structure of what the document is about, and it fills in a lot of details. So it isn't just total generality to look back to the document and see what it says. And you can get a fairly good idea of what those values are like. So we rely upon values, we rely upon purposes, and I think we also rely upon a very general overall objective, which, to go back to the Cherokees, or to go back to Marbury versus Madison, or to go back to what was in Hamilton and Madison's mind, it is an objective of having a document that we're not just going to hang up in a museum. It is a document that is going to work in practice to guarantee those things that it guarantees, but more importantly, to allow the different parts of the government to work constructively together. So I want to show that in different areas of the law, for example, a lot of what we do is statutory interpretation. It is up to the court to try to look to purposes in order to allow this set of institutions to work better cooperatively. And a lot of what we do in different areas of the law, whether it's administrative law, whether it's statutory interpretation, whether it's federalism, whether it has to do with stare decisis, whether it has to do with how we treat lower court opinions. A lot of what we do is trying to get these institutions to work better together. All right? Now, I try to illustrate that. And if I were going to go on and illustrate it too long, you would decide that this is the same as the book on regulation, and you would look for the Hume's History of England. But I will give you one example. And the example is simply this, because it's the hardest, one of the hardest. How are we supposed to cooperate with the president in an area where he really has a lot of constitutional power? I mean, the Constitution gives to the president the power to see that the country is secure, particularly when he acts together with Congress. And one group of people who are not in charge of the security of the country are the courts. But we do have something to do with protecting basic civil rights. And so what happens when those two things conflict? How do we deal with that? And I think the secret to that one is we don't want the president to go too far. Another bumper sticker. Not a blank check. Another bumper sticker. But let's illustrate it, you say. And then you'll see more of the nature of the job, even if I have to do it in 3 minutes by summarizing it. I mean, let's look at an example where I think, and most people now think, the court fell down on that civil liberties job. I grew up in San Francisco. I can remember my mother taking me down by Tanforan race track when I was a child and say that's where they held the Japanese in World War II. And what she was thinking of, and the voice of approval was not there, she was thinking of the fact that they took 70,000 citizens, the Army, General DeWitt from the 6th Army in the Presidio. He took 70,000 American citizens of Japanese origin, and they were moved to camps against their will, where they spent 2 or 3 or 4 years. Well, that case made its way to the Supreme Court in 1944. And the whole rationale for this had been that DeWitt had written that these Japanese, they'd been signaling the submarines offshore. People were afraid of an invasion. They thought there might be an invasion of California. He said there were acts of sabotage. And a couple of lawyers in 1944 in the Justice Department were a little suspicious of this. They called in the FCC. And they said, well, what were these 700 instances of signaling? They asked the FBI, what were the instances of sabotage? And 2 weeks later, the FCC came back with a report and said there were none, not one. These, for the most part, were buck sergeants or privates who didn't know how to work the equipment. And the FBI came back and said there was no sabotage. They said to the FCC, how'd you do this report so quickly? He said, well, we didn't do it quickly. We did it at the time, and we showed it to General DeWitt. And he knew all about it. And the FBI said, but J. Edgar Hoover was against the internment, which he was. And the person who was for it was Earl Warren, Attorney General of California. He said it was the worst thing he ever did. He was not happy with himself. But 6-3, the court upheld it. 6-3. They upheld it in 44. There was no danger in 44. There was no danger of Japanese invading. So why'd they uphold it? And the people who wrote the opinion, Black, great civil libertarian, Douglas was on the same side. Black, Douglas, Frankfurter, all the people later, and Brown, and they wrote that opinion. The people in dissent were Roberts and Jackson and Murphy. Murphy, nobody ever heard of. Read his dissent. It's a great dissent. He's got the facts all right. He's got them all there. I phoned up. His law clerk was still alive. What's his name, who wrote the book about the Supreme Court procedure. I phoned up his law clerk. He's 90-some-odd years old, and I thought, someone must have told them these facts. They must have found out somehow. And unfortunately, he'd forgotten, so we'll never know. Nonetheless, I mean, it's a very, very good opinion. So I go back, I said, how is it that these 6, what are they thinking? And what I think they're thinking, reading is they're thinking, well, somebody has to run this war. Roosevelt has to, or we have to. And we know we can't. And therefore, he does. Period. End of the matter. All right? Now, I think most people think that's a mistake. And it was a mistake, in my opinion. But now look at Guantanamo. Contrast it. We've had 4 cases on Guantanamo. 4. In each of those cases, they've been brought by someone who was detained, not popular person. One of them was the chauffeur of bin Laden. No, chauffeur of bin Laden is not a popular person in the United States of America. And they're all suing the President of the United States, one of the most powerful people in the world, and they all win. All 4 of them win. One case, they set aside a statute of Congress which tried to set aside the writ of habeas corpus. They said Guantanamo, we said Guantanamo is part of the United States and the writ runs to Guantanamo and so forth. Now, if you read those opinions, you'll see they're a little vague. I mean, the writ runs to Guantanamo, but the sense that does it run to Afghanistan? You've opened a Pandora's box here. And you know, the majority doesn't seem to respond to that. It says, you said, for example, that you have to have, if someone says in one of these cases, he says, I was not an enemy combatant. You might hold enemy combatants, but I was a shepherd. And the Army says, then why'd you have a machine gun? So he says, well, you need a machine gun if you have a shepherd, if you're in Afghanistan, I'll tell you. But anyway, there's a dispute there. How do you resolve it? The court says have an independent decision maker, neutral decision maker, have an opportunity to present proofs and arguments. You know, the civil liberties community says that isn't very good, really. I mean, it's good, but not good enough. And the dissent says, you've gone too far. I say, well, it's a little vague here. Why? Why? It's the president's power to secure the United States. There is a problem. It's not as if there's no problem. But it's our responsibility to see that civil liberties does not disappear. Well, can't you be a little stronger than that? Yeah, maybe. Maybe. What I'm trying to do for you is to sketch the nature of the problem as to how what we're trying to do is to find a working relationship that will give meaning to the different provisions of the Constitution, particularly those that we're most in charge of, the civil liberties part, even in time of war, even where the other power of the other branch is at its peak. And those are the difficult kinds of questions that arise in these other areas. I'm trying to give you an example of an approach that doesn't have answers, but it does lead to opinions that in individual cases can be judged on the basis of reason, etc. And that's what I want people to see too. And I have to admit, my motive there is not entirely restricted to those who are not judges or lawyers or law professors or law students. Well, there we are. That's what I'm trying to do. In part, I'm trying to explain why it is that I still get really a kind of thrill. I mean, I'm explaining the court. I'm explaining the court. And I think somebody who isn't a lawyer or isn't a judge still can even understand the administrative law part, but maybe. Anyway, I'm trying to explain what we do. You know, 5 pages on what the procedures are, some of our unwritten rules, some of the history, and somewhat of an approach. And I want to do that, as I said, in part because I still get a thrill every single time I'm in that courtroom, the same as it was the first day, and I see in front of me people of every race, every religion, every point of view. And they've all decided to come into that room and resolve their differences under law and not in the streets with guns and rocks and stones and so forth. And as I said, the only thing I can think of the judges can do, just the same as you, just the same as law students or professors or others, is explain when somebody will take the time to listen what your job is about, why you went into this field, what it has to do with, what you're doing for other people, and you are, and get them to listen if you possibly can. So maybe they will bring civics back. And maybe they will say what to the students in high school, never too early, you know. Understand your institutions. Understand them. Know something about your history in this country. And participate in the life of your community in some way or other. I don't mean to lecture to you, but there I just have. And that's what the book is about. Thank you.